Happy Saturday.
Happy Saturday to you too.
It's great to see you. I feel like in person, actually getting to meet you, even though
Yeah,
we're
it is strange, isn't it? You see people on YouTube a lot and you feel as though they've been in your home and you know them. And of course, it's not quite true.
right. Exactly. I know I'm always talking about my friend so and so, and my husband's like, who is this person?
Well, I did meet Gossip yesterday. We had lunch together. She only lives about 10 minutes or 15 minutes away. So that
Oh,
was neat. That's the first time I've met anybody in person, mano a mano, that
yeah,
I've interacted with through the video screen.
that's cool. Were you able to eat or were you laughing so hard the whole time?
Well, we we sat at the table for more than 2.5 hours,
She,
but we
she
did
is.
eat also.
She's a
But
riot for sure.
uh,
Well, I am just thrilled that you're here. I know we've got a ton of people in chat, so welcome. I am Leslie B with True Crime in a Minute, and our guest today, I don't even think she needs an introduction, but
oh,
it's
please.
our very well-known Jo Patuto, a retired constitutional law professor from the University of Nebraska. And she's recently just launched her own YouTube channel and she's taken off. And she is really focused lately on legal analysis and true crime cases that many of us follow.
That's right.
Yeah. So, well, I'm thrilled that you're here. And I love learning from you. I love how approachable you are. And I just think we have so much that all of
Thank
us
you.
have to wonder. So, I think if anybody is new to my channel, y'all know I've gotten really into the presentations. So it just helps me to have talking points. My background is in corporate world, business
Mhm.
development for over 20 years. And so this is just my comfort zone. It just helps. And I think it helps everybody because I know sometimes, you're listening on your phone or sometimes you have it on mute and you're just kind of watching the screen. So, but what I was hoping we could do today is talk about probable cause affidavits. I would love a little more information on that.
Sure.
Um, prosecutors and law enforcement and how that works. And I'll get into more details. And then just proffers. So that is the goal of today's discussion. I put on here the probable cause definition that I got off law.com. I don't even know if this is accurate. Why don't you
I
tell
did
us?
a probable cause definition in one of my videos because I'd heard it defined so many times and not correctly that I finally, in one of the videos when I was doing something else, did something that explained it. Let me read this one.
Yeah, or I can read it out loud if you want me to.
Okay.
It says sufficient reason based upon known facts to believe a
Well, I
crime.
can see something that's not quite right already.
Oh, okay. Well, then I'll just.
No, leave it up because, it's not, probably most of it is okay. A sufficient reason based upon known facts to believe a crime is committed or that certain property is connected with a crime. That's right. But that's not completely right because you can have an arrest warrant or a search warrant. And for an arrest warrant, what you need probable cause to believe is that a crime has been committed and that the person you're arresting committed the crime. You don't have to be talking about property or anything else. You need to have probable cause of a crime, person committed the crime. Probable cause for a search requires that you have probable cause that a crime was committed and that the person or place that you're searching will give you evidence of the crime. So for probable cause to search, I don't have to suspect you, Leslie, of doing a thing. But if I have probable cause to believe that there's evidence or a gun that was used in the crime in your house,
Okay.
I can search your house with my warrant, even though you're completely uninvolved with the crime itself. So those are the two places. That tells you the two type warrants. So what they said was right. It was just not complete. Then probable cause must exist to make an arrest without a warrant, search without a warrant. That's really not stated very well. You need probable cause even if you have a warrant.
Okay.
But with a warrant, you show the probable cause in order to get the judge to issue it. But it isn't as so if you have a warrant, you don't need probable cause. You always need probable cause.
Okay. So, you know what this makes me think of is the Brian Walsh case. So they were renting that house, or his mom was renting it in her name. And
Right.
they had probable cause, right, to go in there where Brian Walsh and
Right.
Walsh
Right.
lived. And
Right.
they
And
trashed
what?
it.
Go ahead. Sorry.
Oh, yeah, no, they've just like destructed it because they're looking for evidence, and that
Right.
owner is suing.
Right. And there's a reasonableness feature to the Fourth Amendment. So if I say I'm looking for a suitcase, I cannot pull open your bureau drawer because I'm not going to find a huge suitcase in the bureau drawer. So the warrant is also going to define the scope of the search, where I can search. If I say, on the other hand, I'm looking for a diamond ring, then the world's my oyster,
Right.
because a diamond ring can be anywhere, and it means I can open and look anywhere that I want to look for the diamond ring. So, but the other thing that this doesn't do, and it's really amusing, and I know why, is it does not define probable cause. It tells you when you need it, and it tells you you do need it, but it doesn't tell you what is the thing that you need. And that's the tough part about probable cause. Probable cause is the quantum of certainty you have to have in order to do the law enforcement thing. And law is all that. If you're thinking about a criminal trial, the quantum of certainty the jury needs to have to do what it's going to do, to convict, is proof beyond a reasonable doubt. In a civil trial, the quantum of certainty that the plaintiff is going to need to show to prevail is a preponderance, which means just a little bit more than halfway. 50 point, you can run 1,000 zeros and then a 1. You've got a preponderance. Probable cause is less than that, even though it says probable. So it sounds as though we're talking about a probability, which sounds as though more likely than not. It doesn't mean that. So it's not as much as more likely than not, but it has to be enough to give the judge or to show that you had enough reason to go in. I usually, when I'm teaching a class, say it's around 30% certainty. You can't ever say that in a court. We never use percentages, but that's what I give students, is kind of a ballpark idea of how certain you have to be that you're going to find the thing you say you're looking for in the place you're going to say you're looking for it, which is the search, or how likely how certain you have to be that the crime was committed and this person did it, and that's the arrest.
Okay. So recently watched, it was when Ruth Markel spoke for the JAFCO event. I think it was like 2 years ago, and Dave Ehrenberg spoke briefly, but he talked about like probable cause has to be here, but then to prosecute, or it's got to be here. Would you agree with that?
Right. And the thing is, if I can just add a little to this, and I hope I'm not being too pedantic about it.
I love it. That's why you're here.
Oh, not to be pedantic, please. No. The thing is, in a trial, criminal trial, you don't, the prosecutor doesn't have to show that every little piece of evidence that goes in shows proof beyond a reasonable doubt. Somebody can get on the stand and lie about something. You saw a burglary being committed, but the reason why you saw it was you were in a hotel room with your paramour, where you shouldn't have been, and you don't want your husband to know you're having an affair. So you lie about that part, but you're placed where you can see what you said you saw. That happens at trial sometimes. I can be partly right. I can testify and be right about things and not about others. The jury does not have to decide that everything that anybody says when they get on the stand meets a proof beyond a reasonable doubt standard. If that were true, we'd never have a conviction. Wow. What the jury has to decide is based on all the evidence it saw. Does it believe in the totality the evidence shows proof beyond a reasonable doubt? And they can say, as the jury in Donna's case, the couple of jurors that talked about it afterwards, one of them said they didn't believe one of the informers at all, and they didn't believe much about the other. That's what they're telling you. That evidence was there. They certainly didn't decide that Drina convinced them beyond a reasonable doubt that what she was saying was true. It doesn't matter. What matters is when you look at it all, the jury says they have enough to meet that standard.
Interesting. What you just said about the paramour in the hotel. So I was reading up on the Barry Morphew case. Are you familiar with that one at
Mhm.
all? And that wife apparently had been having an affair with like a high school guy. And he, I guess, realized she was missing, but then he just goes and deletes everything because he doesn't want to go public that he's been having an affair.
Yeah.
Like, he wasn't guilty, but or involved. They've, proved that because he has a home goods receipt or something.
Yeah.
But he just deleted all his chats and everything with her because he's like, oh crap,
Yeah.
So that's just proof to show, don't do what you're not supposed to do. Right.
Mm-hmm. The other thing I will say about probable cause, maybe I'll say two things. One, it cannot be simply the officer's judgment that there's probable cause. The officer has to be able to point to objective facts that would lead somebody else who's not involved in the law enforcement investigative enterprise to come to that conclusion. It's easy to see when we go to the judge to get probable cause because that's the independent person. So you can't go in and say, I saw Leslie enter the bank to rob it. Mm-hmm. That's your conclusion, but it doesn't tell the judge anything about what it was that led you to believe that Leslie was going to rob the bank. That's what the judge has to hear. Mm-hmm. I always felt that a really good law enforcement officer, if she said that to you, was right. Mm-hmm. But that isn't enough. She's got to be able to articulate what it was she saw, what it was that she heard, the circumstances surrounding it that led her to come to the conclusion. And sometimes that's hard to get out of somebody. They can tell you, I know, but it's hard for them to be able to articulate what were the things that got you to that conclusion. That's what they have to be able to do, because it has to be the independent and neutral person who ultimately makes the call. If you get the warrant, it's done in advance of doing it. If you don't get the warrant, then you're into a motion to suppress, and it's done after the fact. But either way, you've got to be able to show things that leads that neutral person to draw the conclusion you drew.
Yeah, that does make sense. It makes me think of like Luis Rivera's proffer when he says, and Sigfredo says, or Katie says, I know, when Sigfredo, and they're like, wait, how do you know that? Can you hear that? Like, they got very specific. Right.
And you talked about the affidavits. You see in the affidavits, they're giving a lot of information from which Judge Everett can draw the conclusion that there was probable cause to support the arrest, which is what they want to do.
So I guess it was a great segue. Thank you.
You're welcome.
So
I'm a cooperative guest.
It's been interesting to pull all the different probable cause affidavits, like Sigfredo's, and then Katie's, and then Charlie's, and then Donna's, because they all just keep building, right?
Yeah.
With more and more. But I guess I mean, we all know we want to see the W arrested. But as I read all this about Katie's involvement and then Charlie's and Donna's, I'm trying to understand, what would Wendy's look like? Because I think it would look very different. Well, some of it will look the same. Well, we probably should look at what's in them to be able to say where it would be different, right? Well, I mean, I guess when you get down into like all the different timelines on where the cars were and like the texts and the wiretap calls and all those things, I mean, for what we know, I should say, we don't know what they have. So I was a little disappointed, thinking, well, what are they going to put in hers? I mean, she changed. Well, remember, you don't need the timeline to get to Donna either. Yeah. For Donna, you don't have to know when the car was where, which rental agency they used to rent the car, whether they did it twice, where was Catherine McBanoa at the time she phoned Charlie Adelson. That's not directly relevant to what Donna did, which was set it up and then pay. But in terms of the crime itself, it's all part of the circumstances of the crime. So typically you've got that in there, particularly since
this probable cause affidavit is going to be the beginning or among the beginning documents to then move to a showing for an indictment. And so, you don't want to be subject to later in a suppression motion or something else, the defense saying, well, you didn't say all this before. So they tend to be over inclusive and get all the other things in. Wendy's will be different in that what will need to be done there is to point to the things that connect her to the planning or the agreement to do the crime or to the aftermath. And those things are not necessarily in these affidavits. So what I'm saying is it may be that hers is longer, not shorter, because that's why each one of these has gotten longer, because they're doing the initial information and then they're adding on, this is why this person is involved.
Right.
Same thing with Wendy. They'll just be giving more.
So would she be a first degree murder charge, you think, or you think it's more? I mean,
that's tougher. And it's partly because of Florida law and how Florida talks about that for first degree murder, you have to show that the individual did something. Could be talk, but you've got to show something tangible that connects. And that I think will be harder for Wendy. I don't know whether the prosecution would still charge it and then go to the jury and have the jury say there wasn't enough here, or, go to a judge on the defense might make a motion to dismiss and say there's not enough on this one, rather than at the back, at the front end, just decide we're not going to go for it. But conspiracy for her should be easy if you run the inferences in terms of everything that happened in a way to say she did it.
Yes.
There are different ways to run inferences. But if the jury were to run the inferences in the way that most of us have run the inferences, there would be enough to convict a conspiracy. Conspiracy requires an agreement, and that's all.
Right. So I could see the conspiracy part, but the first degree, I mean, obviously I'm not a lawyer, but so Angela Grace says, so Wendy's stating she hates Dan. She drives to the crime scene and she was the main beneficiary. Would that be in the probable?
No, not the way she phrases it, Angela Grace, because what you have to show is she did for murder one. You have to show that she did or said something to facilitate the commission of the crime. This shows that she certainly had maybe a guilty intent, but you got to do a little more. Now, for the driving to the crime scene, if you want to make the argument that she did that in order to confirm for her brother and her mother that it actually happened, maybe you're getting a little closer to it. The things for her are more likely going to be, if you're going to try for murder one, the fact that she asked Dan if he was going to be in town that weekend. Let me think of what else she did. The fact that Donna had his license, the car license plate number, from which the jury could infer, why would she have it unless that was to be able to let the hitman know this is the car you're looking for. Those are the sorts of things that you can say, if you read the inferences that way, that they facilitated the commission of the crime. And that's the information that would be needed to move her to murder one, not the, she was going to benefit. Sure, she's going to benefit, but benefiting doesn't show she did anything in aid. Now, she might have said, you got to kill him because otherwise I'm going to have no money. That might be enough. It's probably not, but at least you can make an argument that those are language that's aiding in the commission of the crime. But that's what you have to find.
Well, I think a lot of the one of the big pieces that came out in Donna's trial, we'd always seen transcript, I think, of Dan's voicemail, but when they actually played it, the voicemail where he left what he was doing that morning for Wendy,
right?
I thought that was pretty big.
I did too. Yeah. But that's what you. But the fact is, that's what you need, and there isn't a lot that really you can point to that she did or said to facilitate murder one. There's
Mhm.
much more if what we're talking about is conspiracy, that she agreed to the commission of the crime. If you can show the agreement, that's all you need to show.
Right.
Now, again, to show the agreement, you're going to have to show something, you
And see,
know.
that's what I mean. Part of me, not a lot of me, hates because, like, if she was arrested on first degree charges, but I mean, can they do that? We know she would be in jail until trial. But on conspiracy, I mean, she could have a bail, I think.
Well, she could, but the question is whether the judge would give it or not.
Mhm.
I don't think the judge would find, off what I know, that
Mhm.
she's a risk, you know, to harm others.
Yeah.
But she might be a flight risk. She
Mhm.
speaks Spanish.
Mhm.
She's living in Texas near the border. She's got
Mhm.
money to be able to manage the, you know, the flight. And something that I learned just a week ago from a couple of people in the chat with regard to the ankle monitors, which I always thought was like a GPS. As soon as you left the house, they knew you were going. Um, uh, they don't, if the people in the chat were correct, and there were 2 or 3 different people who gave me the same description, they don't work that way. They're tracking devices that you can look at afterwards to say this is where this person went, but they don't alert in real time, here's where this person is going.
So we just put a bunch of air tags on her. Yeah.
AirTag, I don't know how AirTags work, but
Yeah. It's like
if in fact they give you real time, that would work. I don't know if jurisdictions use AirTags.
Well,
But if she's got an ankle bracelet, even if they did that, given that she's got money,
mhm.
and she certainly speaks another language, and she's certainly smart enough, and she may have access to people who have, you know, can
Yeah.
doctor a passport. I mean, I wouldn't know where to go,
Right.
but she might, or
Yeah.
know people who would know people.
She might. In that
Yeah.
Brian Walsh case, I remember he had an ankle monitor, but that's where we learned it doesn't do the real time. Now, I don't know if federal ones are different than state ones.
Somebody said that they're not set up that way. I mean, people in chat said they're not set up that way. I can't speak from personal knowledge or having tried to, you know, talk to people who are
Mhm.
experts in this field.
Yeah. So do you think, based on what you've seen, I mean, I think you do think they could convict, definitely, like you said, Wendy, of conspiracy, but we're not sure on first degree. I mean,
Yeah. I think there may be enough that they can point to bring the charges, whether they would survive a motion to dismiss for murder one. I'm less sure. I think if it went to I think if it went to the jury and jury testified, the jury might well convict her of murder one.
mhm.
But I don't think she'll testify at her trial. And
Oh,
I've got a video that I did. I did a video on not all the evidence that you could point to that we
mhm.
would say tends to show her guilt,
Mhm.
because that's not going to matter at trial. What matters at trial is the evidence that's admissible. So I did a video just talking about the evidence that actually looks like it could get into the trial for the jury to consider.
Right.
And the trial would be, for the prosecutor's point of view, would be much better off if she got on the stand. She's a better witness than she was in that first trial, but she's still not a great witness. And as smart as she is, she still has this instinct to say or do on the stand something that she shouldn't.
Yeah.
And we've had 3 juries now. Let's see.
4.
We had Garcia's, then Magbanoa. We've had 4 juries, and I
Mhm.
think in at least 3 of them, there's been at least one juror who has talked about it, and
Yeah.
none of them have liked her, and all of them have said they thought she was involved in some way. So if she
Mhm.
gets on the stand, you would think that you know that way of looking at her would continue, but you've got to assume she won't get on the stand.
Right. Yeah, I definitely assume that.
Yeah.
Never give up. What are the chances the state has more evidence than we've already seen?
Well, we don't know what we don't know.
Yeah.
It's possible, because in every one of these trials, we've heard something we didn't know before. Maybe it's only a little bit, but it's something in addition. So it's possible that they have more, particularly since we're not going to put in evidence in any one of the trials that they didn't need to put in that would implicate Wendy because of her immunity. And that would just muddy the waters for her trial and having to show that the evidence that they had was independent of anything she said on the witness stand. So there may well be something. I don't know what it might be. I have always guessed, but now we're 11 years out.
Right.
That given the way Donna planned her entire life and had in meticulous detail in those diaries, everything she did from the time she got up until the time she went to bed, that I just found it hard to believe and find it hard to believe that they had nothing in place as to what was going to happen when Wendy left Tallahassee, such as, and they did, she canceled the cable, but things like that. I'm told that in Miami, you just can't register kids in the better schools. You've got to get on a waiting list.
Right.
So would there be evidence that they put the kids on the waiting list before Dan Markel was killed?
Right.
You can think of all the kinds of things. Would Wendy or Donna have had Google searches about movers to use? Or, things like that. And Lacoste talked about a couple of them. She used to have the kids' drawings on the wall. And the last time he was there was none. One of their friends said that Wendy gave her, just a pile of clothes from the boys that, they were too big for. Now, of course, they're too big. You're going to give them away sooner or later. But they're all happening in that time frame. So they all go to paint a picture that the jury could use. And I have always felt there was more. Now, 11 years out, it may be that, there was more, but nobody was thinking about it at the time. And they don't have any of it. Yeah. But I don't know what, things you still might be able to find a record of, or what they might have found way back, 11 years ago or 10 years ago or 8 years ago or anywhere in this time frame.
Well, and we learned too that they added her to the lease at that continuum.
Right.
And that was way before Dan. I mean, that was, we had all kind of been talking about it online, but it was actually out.
Right.
In the trial.
Well, and this was the first time that we knew that Donna had in her day planner Dan Markel's license plate, which you would think she had to get from Wendy.
Yeah, I guess.
And why would she record? She's the only license plate number. Apparently, she recorded in the entire day planner. Why? He's 11 hours away in Tallahassee. He's not going to have his car in Miami. And even if he did, why does she need to know the license plate number of the car?
I was listening to that. I always have my AirPods in at work, and I was listening to it live, and I went, oh.
You had your aha moment, huh?
Yeah, I was like, oh my gosh. I mean, I was, it takes a lot for that. And I was just shocked. Kate, if she's only charged with conspiracy and convicted, could she later be charged with murder one if more comes out? That's a good question.
I think the answer to that is yes. I'm answering it tentatively because number one, I haven't thought about it before. And number two, there may be something in Florida law about it, but conspiracy is a different crime from murder one. So it would be like she's charged with burglary and murder one, or robbery and murder one. You can go forward with the robbery, and then if later you find more evidence for murder one, you can go back and charge. So I think it should be analogous to that, and the answer is yes. But as I say, I'm willing to say it, but I also want to say it's risky to go sort of walking out into territory one has not explored or even thought about before, because the law is not always logical. And what should happen based on what the law has said in the past is it not always what does happen.
Yeah. I wonder how many years, would she get for conspiracy?
Oh, I think isn't it 30? The conspiracy to commit murder gives you the same amount of time as the crime itself. I think that's the way it works in most states. I think that's what it is in Florida. And I don't know whether because murder one is life without the possibility of parole, I don't think that would carry over. But murder two, I think, is 30 to life in Florida. Don't hold me to it, but I think that's what it is. So,
I mean, we've all talked about it. I know we're beating a dead horse, but it's like, what is the problem? Why are they waiting? I mean, I'm sorry, I didn't hear that. Can you repeat? Why are they waiting?
Oh, your guess is probably as good, if not better, than mine. My guess had been that, having gone through this trial so many times and having just finished it this time, and with Sarah Catherine Dugan maybe going on the bench, that they didn't want to do anything until they knew about that, because if they were going to bring in another second chair, that would slow things down.
Yeah.
Jack Campbell had said, they're really busy, they need a timeout. And they do. They have lots of other cases. It isn't as though the only murder case that Sarah Catherine Dugan or Georgia Kappelman had was the Markell murder case. They've had, retirements. Detective Isom retired, and now Sergeant Corbett has retired. And, it doesn't mean that they can't come back and testify, or you can't do it with another expert, but all that has to be put together. So my initial guess was they were going to take some time to get all that worked out. Mm-hmm. I had somebody yesterday in my chat ask if they were waiting on Charlie's appeal. Because I had been asked, did I think Charlie might turn on Wendy? Mm-hmm. And I said, I don't think Donna ever will, because her goal in life is to have the boys think she had nothing to do with it. Mm-hmm. But I thought Charlie might, because he's sitting in prison. He gets a Wendy's, that he's just salivating over when he's being transported to Leon County because he might testify. Whereas she can go out to a lobster dinner and have champagne on New Year's Eve, and is living the good life. And I opine that if I were he, mm-hmm. I would say enough is enough. If I'm going to sit here for the rest of my life, you should come join me.
Right.
I don't know if that's how he would think about it, but it seems to me he's at least, my view of him is it would be within the range of what he might do.
Right.
But that means, the appeal, the oral arguments coming up in another, week, February 3rd, mm-hmm. 2 weeks, whatever it is. Mm-hmm. The decision on that appeal won't take too long. But he then has the conflict of interest issue with regard to Rashbaum. That mm-hmm. couldn't be handled on the direct appeal. It's going to be handled on a collateral attack, which means if his appeal is denied, which is what I think will happen, he can then go back in and file. He might have to start in state court. I don't know how Florida does it, challenging the conviction because he had ineffective assistance of counsel. And that was because his lawyer had a conflict, knowing he was going to represent Donna. He didn't do some of the things at Charlie's trial that he otherwise would have done. Mm-hmm. Then he's going to be in federal court on a federal habeas corpus petition and make the same claim. And whether he wins or loses, there's likely going to be appeal to the Court of Appeals. And that can take a year, 2 years, 3 years. It takes a long time. So if they're waiting for that to be over, it's pretty depressing, because we could be looking at quite a period of time before they get around. And at that point, they may then relook at it and decide, so much time has passed, witnesses have died, moved away, memories are going to be even harder, and they may then decide not to go forward. So I hope that guess, although it seemed to me to be reasonable, turns out not to be right. I hope maybe they'll wait for the appeal and then make a decision. But as I say, my guess is no better than anybody else's.
Yeah. I saw your video on the February 3rd, the oral arguments coming up. And I was wondering too, how long before they make a decision, but you just said you don't think it would be very long.
It shouldn't be that long now. I said there, it could be up to a year. I don't think it should take that long, because they've read the briefs. They're going to have the oral argument. It will be decided before the end of this term. And I can't imagine it would go that long.
It's just gives me anxiety. I was going to pull Corey Richens. So her trial's starting soon. Are you familiar with her, Jo?
Another author.
Well, yeah, if you want to call her that. But she is in Utah, and there is so many charges against her, and supposedly gave her husband an overdose of fentanyl, and she's got all these federal charges with mortgage fraud and all this. But
which I think they decided, like, sometimes I get some of these cases muddled in my head because there's so many of these, that the other charges that if it goes forward, it will go forward on the ones related to the homicide.
okay, I think I saw like she's being charged with 9 or 10 different things. I was losing count on.
Yeah.
There were so many different ones, but I'm looking forward to that one.
And they're doing the controlled substance, which would be related to the homicide.
Yeah. Well, I think and that's, I guess my point to that was I pulled hers to see, okay, so it's showing her involvement. I mean, that's a easily first degree murder charge, but like with Wendy, I just, as much as I hate it, like I couldn't get there, but.
Yeah. But you haven't seen what they're going to write yet.
Yeah.
I mean, in Corey's, you see how they put it together. Same thing in all the other defendants here.
Yeah.
We haven't seen the way they would frame it for Wendy.
Yeah. And speaking of whose probable cause we haven't seen, Patrick Galvani, our own my father's alibi, Allison's dad, who was arrested in November. And she said it's okay that I can give this update. She told Joe and I that we could, but we didn't really get anything online, right, Joe?
I couldn't. I didn't have a lot of time when we got that information to be able to find it.
Yeah.
But we know generally, what happened. The police investigated him at the time and then didn't go forward, even though I think they brought charges and then finally dismissed the charges, even though it looked as though there was a boatload of evidence that connected him to the crime.
Yes.
And as I recall, and Leslie, you can fill in, she was at some function that I think she might have been partly the arranger, and he called to say, you have to come now because I can't keep Allison overnight. I have something to do. So she left the party saying, I'll be back, never returned. The car she was driving was found in the garage. And did they find some? I'm trying to remember what they found in the car. Allison didn't stay with him that night. She was sent to stay with an uncle his name also was Patrick. She had never stayed with the uncle before. And that's why she named her podcast or a channel, My Father's Alibi, because she believes, and certainly the evidence would support it, that he used her to give himself an alibi for the crime. Right.
And that was her mom's car that was in the garage that Allison remembers her mom kept the sleeping bag in that they had a picnic on. Right. And then the mom was found in that sleeping bag in the bay. And then the neighbor saw the mom's car in the driveway. So proof that she did get there, because he says she never did.
Yeah. And I think most of the witnesses are still alive and they know where they are. So it isn't as though they've lost substantial evidence. And Allison has a really good memory for what occurred. I think in that trial, they're going to go after her as a 5-year-old and what could she possibly remember and what has she kind of reconstructed in her head that didn't really happen over all the years. So I wouldn't be surprised if they don't have an expert on memory in trying to attack, her, what she says she remembers from the time.
She gives such vivid details. I mean, a Laura Ashley pillow, and she explains the sleeping bag and how they went to see Annie. I mean, those are some details.
Right.
But it shows kids do remember, just like Wendy was asking Jeff.
But I don't think she was interviewed at the time. So there's nothing that you can nail to, if the expert witness wants to say she could have made all this up, there's not much, if anything at all, that you can ground in what she was saying then.
She does say, though, that a lot of the things that he said in a police recorded call corroborate her memories of the day and
right. So, right, but you've got to it's which came first,
right?
And that's the, it would have been nice if they had interviewed her and got her to
Right.
get on the record as to what she knew before she knew.
Yeah.
The
Well, it's such a
circumstances.
mess because they said, "Where were you?" And she said she was with
At
Pat.
Pat,
So then they thought that was her dad, but
father. That's right.
yeah,
That's
it was
right.
awful. And then he had a Mercedes that he loved. He hated that Buick, but he sold it and drove Nancy, the mom's Buick, which makes me wonder, like, was there DNA in that Mercedes? Is that what he
Yeah.
put her into driver,
Right.
So,
And you know what they're able to do with DNA these days?
yeah, I know.
I don't know if he still has the car, where the car is,
Well, it made me start thinking about the Prius and the Dan Markel case. I mean, they hunted that thing down with the VIN and found out AAA owned it.
Right.
So maybe
Right.
they can track this Mercedes down. I mean, a lot of people collect those cars.
What I think is interesting, or one of the things I think is interesting currently, is he's sitting in jail and hasn't really, locked in who he wants to hire as his defense lawyer. And you would think that he would have wanted to get that done right away and then have a hearing on being released. I mean, he's been around in the community for how many years? 40 plus years. He hasn't committed any crime we know of.
Kind of been living like a hermit, I think, in that same place in San Francisco. Still in jail, has been there since November. And he's still trying to, like you said, on the attorney, trying to figure out the attorney that he wants is wanting a huge retainer.
Yeah.
So, but arraignment's coming up on January the 15th. So we'll all see what happens.
Yeah.
But this is going definitely to be one to watch. And it's one to keep like our hope alive. I mean, 1982, that happened. And here it is now 2026.
Yeah, it's it's a tribute to law enforcement and the prosecutor that they're willing to go back that far to try to correct a really terrible wrong. Because they're inundated with new trials and new crimes, and some that are more current in that the person out there might really be a current danger. And I know, because if you listen to people who work in cold crime units, that they are really dedicated to try to correct and go after, the felons or the murderers or the child, essayers from years ago, and not just live in the moment. And I think it's a real tribute because those are hard cases to put together.
Yeah. So that brings me to that question. I mean, we know that this is all because Adelson created a movement on YouTube and got so many people sending letters and things to the DA. Do you think that was part of the reason they chose to look at this again? Is that?
Yeah, I do. Because there are a lot of cold cases, and the question is, and it's not that they're not willing to look, but if you've got a lot of cold cases, which ones do you pick? And even if you're going through all of them, when would you get to this one? And this one is very cold. So I do think it matters that there are people currently who say, we really think this was a travesty of justice and something needs to be done. It isn't enough to move law enforcement and a prosecutor to bring it forward, because they really do have to evaluate whether there's enough current evidence to be able to do it. And they also have to, the prosecutor has to think about it in terms of office resources compared to all the other things that the office needs to do. So it certainly isn't enough by itself, but I do think it is helpful to have people out there advocating. And, and Adelson made a real case for, here's the evidence. And I think she may have also put them on some of the former witnesses, to give them leads to find people. So I think it mattered. I think the YouTubers who wrote, and I understand somebody called and had a long conversation with the prosecutor, which that one surprised me very much. Around here, I don't think an assistant in the office could necessarily get a phone call with the head prosecutor. So I think it made a difference.
Yeah, because some people have talked about, like, what do we need to do about Wendy? I mean, should we be writing Jack Campbell? I just don't know if, I think they know there's a lot of attention on it. So
yeah. I'm sure they know. I do think you're right. It's a fine balance, because depending on the prosecutor, he or she may feel, I'm getting all this pressure to do it. And by golly, I'm going to put my stick in the sand and saying, I made the right decision. I'm not moving. So, you know, you have to really think about what's likely to work. I think in a lot of cases, what's done behind the scenes, so it doesn't look like you're publicly embarrassing law enforcement or the office of the prosecutor, might be a more effective way to do it. And if that's the case, we don't know whether there are people in the Tallahassee area who have been talking to the office and calling the office and encouraging the office. And what really matters, I think, is the people who can call, who really can say they have concrete information. In Allison's case, she had concrete information. She knew some of the people. She had her own memories. In Wendy's case, a lot of us can call and point to information in the record that the prosecutor's office already has. But I mean, I can't call and say, you know, I know what was going on at the time. You know, I know that this was happening. Most of us wouldn't be able to do it. So it isn't as potent. But I do think, I mean, prosecutors are political officers. They're either elected or they're appointed by the political elected officer, the governor. And so they are receptive to concerns or points of view, particularly of their constituency. They have to be. And I don't think that's a bad thing because, you know, the enforcement, the investigation, and the prosecution of crimes is all of our business, not simply the prosecutor's office.
Yeah. I wonder what the Markells would want. You know, I think about that too.
What they would want?
Because they seem to have a good relationship with them. Like, would they, I mean, not what they want in prosecution. Would they want us doing a petition or writing?
Oh, yeah. I don't know. I mean, they're just the same calculus. And, you know, from their point of view, they're in a really touchy situation because they want to leave some line open to their grandsons. And if they were to be perceived to be publicly pushing, you know, they have very little tenuous line now. It might be completely eliminated. So I can understand them being very wary about it. I've known, you know, grandparents in divorce situations who believed completely that their child, you know, was being, child's actions were being misrepresented, and they believed that they had information to share that showed that, you know, the daughter-in-law, the son-in-law was lying and other things, and they're still reluctant to do it because that parent may be the custodial parent, and if you do what you think you need to do, you may lose any contact. In fact, that's what happened, isn't it, with the case out of Florida involving the alligator or the crocodile or whatever, the non-existent alligator or the crocodile.
Denise Williams.
That when the victim's mother started pushing.
She did.
William said, you do this and you're never going to see your granddaughter again. And that's exactly what happened. And the granddaughter always believed her mother's story, and there was never any contact with the grandmother. So the grandparents or the aunts and uncles in that situation, it's really difficult for them to decide.
Okay. So this is my question. You see prosecutors and law enforcement. So we've got like Georgia Kappelman. Of course, she's very seasoned. I mean, she's been doing this a long time. And then Jason Newland is the investigator that works with her. But when they look at a case, I mean, is it up to a prosecutor, Joe, to go, you know what, it's this charge and this and this? Or how do they come up with it? I mean, obviously we can say, oh, murder and conspiracy, but I always think about that.
Yeah, the prosecutors' offices and law enforcement do it differently from place to place, but the general pattern is that law enforcement does the initial investigation. They decide, you know, there's been a murder committed, and they decide, Leslie, that you're the person who did it, and they put together their information, and they can file the initial arrest warrant with the court, giving the information that says Leslie is the person who did the crime. Many places they have to do that in consultation with the prosecutor's office. There are places, I think, when they can do it independently.
Mhm.
When they do it independently, it can be a recipe for disaster
Yeah.
because the prosecutor's office has not really looked at it yet.
Mhm.
So when they work well together, law enforcement will go to the prosecutor and say, this is what we have. The prosecutor may say, I don't think it's enough. Can you find out information here? Can you do this? And they work amicably. It doesn't always work that way.
Yeah.
But ultimately, it's the prosecutor that brings the formal charges because it's the prosecutor that has to move that case forward.
Yeah.
And in many cases, even situations in which law enforcement and prosecutors are amicable and they work together and they respect each other, there can be a real rift when the prosecutor's office may decline not to prosecute,
I'm
or
sure.
to decline to prosecute for a lesser charge,
Mhm.
or to plea bargain, because from the perspective of the police, they see the crime, they've interviewed the people, they see what the consequences were to a victim and the victim's family, but they don't have to think in terms of admissible evidence and hearsay and motions to suppress, and all those things that the prosecutor does have to think about when the prosecutor is deciding to bring the charges or not. So the police have influence, law enforcement has influence, they do the initial investigation, but
Mhm.
ultimately the decision to go forward and on what charges comes from the prosecutor's office, and they draft the formal complaint. If it's a state that's if it's a grand jury jurisdiction, they draft the indictment, they present it to the grand jury.
So does it, okay, grand jury, that's for like a capital offense, right? In
No,
Florida?
in a grand jury state, all felonies go to the grand jury.
Okay.
Now they can do it, they can tinker, but in federal prosecutions, the Fifth Amendment says felony prosecutions have to begin with the grand jury. That the grand jury is going to be the independent eye to be sure that government doesn't tread over the rights of citizens, particularly citizens who don't have much recourse, or they don't have access to having their voices heard. They may come from underprivileged backgrounds. They may be, you name the group.
Yeah.
So the grand jury is supposed to be the buffer. Now, I can give you a big aside. That's not how it works, but that's the theory, and it's embedded in the federal Constitution. So at the federal level, felonies have to start with a grand jury, unless the prosecutor. Well, it has to start with a grand jury. Let me just end there. Some states don't have a grand jury system. They go by prosecutor information. And that means Nebraska is one of those, for example. That means there is no grand jury. Generally, the prosecutor decides what the charges are. Then it's presented to the judge. The judge is the neutral person, and you have a little mini hearing. Anybody who watched those reruns of the Perry Mason shows, all his cases were handled in a preliminary hearing, which never happens. He never went to trial on anything. They'd have the preliminary hearing was only to show there's probable cause to bring this case forward, and somebody would get on the stand and confess.
So, I mean, I don't mean to sound, stupid, but so there's probable cause, but then they have an arrest warrant because of that. Like what?
Well, you don't need an arrest warrant for a felony prosecution committed in public, but let's say there is one. The arrest warrant is only there's evidence that this person committed this crime, but it isn't the triggering document that starts a prosecution. That's the formal complaint that's entered in open court.
Mm-hmm.
And the defendant says, I plead guilty, I plead not guilty, I want to defer a plea to later, that's when the formal proceeding begins. The arrest allows me to go after you. I may be able to throw you in jail for 72 hours, but it doesn't start the prosecution.
Okay. Because when we all watched, or most of us did, the 2020 last night, which was basically a rehash of everything we already know. Right. But I thought 2020 did a better job than Dateline, I think. But we know they were trying to get the arrest warrant for Donna while they're en route to Miami.
Yeah. And in fact, they did not need an arrest warrant.
Okay. That's where I was confused.
Yeah.
Okay.
Public felony arrest, you don't need you still need probable cause. Mm-hmm. But that one not only would be probable cause, but they could have argued exigent circumstances. She's ready to get on a plane and leave the country and go somewhere we can't get her. Mm-hmm. It's better to get the arrest warrant if you have time. It looks more procedurally correct. And in addition, what happens with the arrest warrant is it's ex parte, which means the prosecutor goes, it might be law enforcement with the prosecutor, or it could be law enforcement on his own. Some jurisdictions allow the officer to go in alone. I think the better practice is to have a prosecutor with you. Prosecutor often writes the application. The judge then reviews it and signs off on it.
Okay.
Then if there's a challenge later, I say this was a bad arrest. There was not probable cause. We have a motion to suppress. But at that point, it's my job to persuade the judge that the warrant issued in error. I've got the burden of proof. Whereas if you never have the warrant, then there's never been a neutral entity that has said probable cause. The defendant says the same thing, bad arrest. There's no warrant. The prosecutor has the burden of showing that that initial decision was correct. So if you have the time and you can do it, and you can nail them, and the other thing the application does, it nails everything down in advance of the arrest. So you can't have an argument about, you didn't know that. I mean, if they hadn't done that, and that arrest had been done, and they said, here's all the evidence we had, Donna's lawyers could have said, prove it. You didn't have all this information. You just rushed to judgment. If you do it through the warrant, you clearly have the affidavit and the application that sets forth in great detail everything they knew that constituted probable cause. And you can't have an argument that you made it up after you made the arrest. So always better to do the warrant if you can.
They have to have all that for Wendy. So then that brings up the question we all have seen where Sanford tries to grab Donna's phone and she's like, no. Right. So then did they have to also have a search warrant for that phone?
There's a doctrine called search incident to arrest. I mean, the Fourth Amendment has about 5 lines to it and probably has 20 volumes of cases, well, maybe not in the Supreme Court, but lots of volumes of cases explaining what each word means. So there's a doctrine called search incident to arrest, which says if I'm making a felony arrest, I have the right, without a warrant, to seize and search anything that I find on your person or maybe within arm's reach. Partly because, it's danger to me, partly because it's just going to be part of what the probable cause for the arrest allows me to do. Now, with the phone, you get the additional issue, which is should they have a warrant to look in the phone? The seizing, there's not going to be an issue about. Do they need a warrant to look into the phone?
Yeah.
Theoretically, the answer to that is maybe no, but usually they get the warrant because they're going to be able to say, we made the arrest, we had probable cause to make the arrest, this crime involved many people, we have probable cause to believe we're going to find things on the phone that may be evidence of the crime. And at that point, there's no harm, no foul. To get the warrant, it's not going to be really all that cumbersome. You've already got the defendant in custody or the suspect in custody. You have 72 hours before you even have to go before a magistrate and demonstrate that you have the right to hold somebody in custody. So there's more time to do the affidavit and the application for the warrant to look at the phone.
Because I was just worried, like, what if Wendy's attorney says, oh, they got Donna's phone and something on
Wendy's
there.
Attorney cannot do that, period. Another doctrine in the Fourth Amendment is you have to have a personal privacy interest of your own in the search. So you come to my house, or the police come to my house to search for evidence about you. They don't have any probable cause to enter my house. They have violated my Fourth Amendment rights. If they find anything in that house that incriminates me, it's not going to get into evidence. It is not your house. You cannot make any claim with regard to their illegal entry of my house because it's not your house. So you can't make that claim. You're limited to the thing that they found. And then you have to say it's your thing, which might be something you don't want to say if it's drugs. You know, I say they were my drugs and you couldn't seize them. You can't do it. So Wendy's lawyers can't challenge the search or arrest of Donna because they've got no standing.
Well, good, because that was my concern. Like, what if there's something big in there that implicates her, and then
Doesn't matter. That's nice, actually, because
well,
they have no claim to a violation, to be able to raise a violation of your constitutional rights. They can only raise a violation of her constitutional rights.
very interesting. I love it. Thank you, and thanks, BB Lee. Super nice. Let me go through this next. Oh, proffers. This was the last one. Like, where do they start? I mean, you know, is it like the defendant says something like, hey, I think they're willing to talk, or y'all willing to throw a deal? I mean, I guess it can start on either side.
Yeah. Well, if it can be different things. At the outset, if we're talking about should your client be charged, it's typically going to be the defense lawyer who says, we're willing to make a proffer. And a proffer is, I say, I'm going to tell you what happened, but you can't use it against me, because in case we don't come to an agreement,
Yes.
you just can't use anything I'm telling you. And then I'm under oath and I tell you what occurred. So that would be, it's going to be the defense. Now, maybe the prosecutor says, maybe we'd be willing to give you a deal, but we need to know what your guy did. And then the defense lawyer, the initiation is from the prosecutor, but the defense lawyer then says, okay, we're willing to give you a proffer. Yeah, and proffer means you can't use it. Proffers at trial are often, there's evidence that the prosecutor wants to introduce. And the defense says, you can't introduce it. It's hearsay. There's no way to get it in. And the prosecutor will say, well, I want to give you a proffer on it to know what it is that we would introduce. And then you can tell, judge, whether in fact it's precluded by the evidence rule. So it's a kind of different version of it. But in both cases, you're giving information in advance of the formal testimony about what will be said.
And I think I'm overthinking it, which would be very my style. But I was just thinking, like, let's say, I'm like, okay, I'm going to tell y'all everything that happened, but then I don't like what they're offering me. But now I've just told them what happened. They didn't know that. So now they're like, yeah, well, we're going to go and figure it out. Like,
yeah, no, it's the same thing that works for immunity. A proffer means I tell you what I know in order to get a deal. And that's the agreement. And often you do it in writing. So everybody knows exactly what the consequences will be if you don't come to an agreement after the proffer. And then you can't use the proffer. And because of the agreement, you can't say, oh, God, look at all I found. Now I'm going to go find other evidence. It would be derived from the proffer. And usually you're going to put that in the agreement, but it would be implicit anyway, that you're not going to do it if they're going to use what you say, if there's no agreement, or if they're then going to use it to find out evidence against you. You wouldn't do it unless you were assured neither of those things was going to happen.
I see. So I know we've watched a lot of us, the Luis Rivera proffer, but supposedly there were some other meetings that weren't recorded. And in this meeting, Georgia isn't there, but I was rewatching the first trial because, I have all this spare time. And there's a point where Chris DeCoste is mad. He's bringing it up that Georgia went and met with Luis at the prison, but it's not recorded. I mean, is that typical?
It can be, particularly the preliminary stages when they're talking about, it's an informal, well, what can he give? And this is, we need to know what it is you're going to be able to do and da-da-da-da-da-da. So it can be not recorded until you've reached the stage at which you think that the proffer is actually something that's going to be concrete. If you remember Katie, I mean, she gave, 2, 3 proffers, and she was all over the place, and Stanford left the room. He was so, so upset. Wow.
Everyone would be frustrated. You just
So I mean, you're not, that sort of thing you often try to do before you put a recording on and do it, because you can have hours of recording that is nonsense. So they don't. And it will be subject to, because what the defense will say is there was a reason why you didn't tape it. It's because that's where you made all these bad bargains, and you said, if you lie, you won't say, if you lie, or I need this, if you can tell me this, we'll give you something. And that's what you did, and you weren't on tape.
Mhm.
That's always available to the defense to use, which is why a prosecutor may be cautious about not using the recording from the start or putting it on at an early stage.
Mhm.
But it is not atypical to go some time without. And it's certainly not atypical in these situations for the prosecutor not to be there. Because the prosecutor, if she's there when this proffer is taken and now there's a challenge to what exactly happened, may be in the position of being a witness that the defense wants to call. And if you're called as a witness, you can't prosecute. So
Mhm.
prosecutors often don't get involved, at least in the early stuff, because they don't want to risk that happening.
Yeah, I just think they're fascinating. And in that video with Luis Rivera, in the beginning, I swear I hear George's voice, but you never see her or anything again. And then in Katie's, I mean, one of them, they bring her to the office there in Tallahassee, and then another one, she's in the jail. So I guess it's just whatever works out. But who has to approve that? Like Jack Campbell in Florida?
Yeah, well, it depends on the office. Some offices, the prosecutor gives a lot of autonomy to his assistants or to the higher level of assistants. If you're a newly graduated law student in a case and you want to proffer and you want to be able to give a deal, you probably have to ask somebody else. A supervisor. It may not have to be the head of the office, but you're going to have to go to somebody else.
Mhm.
So it depends on the serious nature of the crime, maybe the complexity of the crime, and the placement in the office of the individual who's doing the prosecution. In a high visibility crime, the guy in charge of the office is probably going to have to sign off on it,
Mhm.
or at least know about the dimensions of it, and then say, okay, you're closer to it, I understand it, now you can use your judgment, but you're not going to cut him out of the picture.
Right. All right. Well, now we know. This has been so educational. I just put a little summary of what we've learned today. More about probable cause, prosecutors, and proffers than
Yeah.
I did have. Oh, I was curious what trials you were going to watch this year, or if you've
Yeah.
looked at them.
Probably the same ones you're talking about, depending on when they go.
Do you know about this one? Aaron Spencer?
I heard a little about it, but it wasn't on my list, but I did hear something about it.
Yeah, I mean, it's starting in a few weeks in Arkansas, but a man was allegedly essaying.
Oh, I did, and he shot him 14 or 15 times in the head. I do know. That one. I think if it's going to be simulcast, so that I can actually see it, because I'm not going to go to Arkansas to watch it.
I know.
I mean that there are a number of cases I'm interested in, but the thing that's going to tip it one way or the other for me is whether there's going to be streaming so that I can actually watch it gavel to gavel, because I would like to watch and comment on it, with viewers.
Yeah.
Do you know if this one is going to be streamed?
I need to research that.
Yeah. This one interests me a lot because
it's different than any other,
because this was a neighbor, wasn't it? Who had essayed the daughter, and he was arrested for it. So they had to have at least some information that it was accurate. And then he apparently takes her from the home.
Right.
And the father notices she's missing, and he calls 911 to say his daughter's been kidnapped. And then he chases after him, and he sees her on a bus with him, I think, and he gets the guy.
Wow.
And I think he might have called 911 again, either before or afterwards, and then he shoots him a number of times. Yeah. That one really interests me because I'm curious as to why they're going after him with such a high
it's shocking.
Charge,
I'm
because
shocked.
I can imagine a lot of jurors who would say, hey, Yeah, you did it yourself, but you called them and you
Mhm.
had him, and he had your daughter.
Exactly. And
So yeah,
I'm just shocked in Arkansas. Like, I would think they'd be like, yeah, I'll go for it. But I think it's because it was 16 bullets or something. I think that is why. But
yeah. But I think what they will say is, he started and then he really lost control, and he kept shooting, but his victim was dead and then he couldn't control it. Who knows? But there was a note in your chat that the person didn't think it's going to be streamed.
oh, I saw that. That's a bummer. Well, it is definitely one of interest to me, but
Me
I'm
too.
not going to
I
Arkansas.
didn't recognize the name until you started to describe it.
Yeah. Of course, Corey Richens.
Oh, absolutely.
Yeah, that one. They're saying 5 weeks, and it's going to be streamed, although her attorneys are trying to fight it. So I think it starts the last week of February.
Yeah.
Yeah. And
That one
then,
I would really like to. I mean, the issue there is going to be the recanting, and then I think the unrecanting again, or maybe just the recanting. Maybe this one is the recanting only of the person who might have provided the drugs.
yes.
And my guess is he had said he hadn't done the drug at that time, and I'm just guessing they may have found other of his customers.
I bet you're right.
Yeah.
This case is in the Bahamas. It won't be on TV, so I'm going to go on site to report.
Oh, good.
I just got to tell my husband no. I really would love
You're going to the Bahamas. I heard you say you were going to go to the Bahamas, but I thought you were kidding.
No, I mean, I'm seriously thinking about it. But her estranged husband, it was another murder for hire type thing, but he got the warning. It didn't happen.
Yeah, and this is the one where she sent a couple of texts
Yes.
saying, go do it now or something like that. I mean, these people are just...
No. But the reason I'm interested in it, so Robert Shiver, who's her estranged husband, he played football at Auburn, and I graduated from Auburn. So I'm just kind of curious about it all. But
well, it would be interesting because it happened in the Bahamas, so it's not going to be U.S. law.
I know.
So it might be, and I don't know whether they,
Mhm.
how they handle juries or anything. So it might be a very, very interesting case to report on.
Yeah, I won't be surprised if she's acquitted, just kind of stuff I'm hearing. I don't know. We'll see. But yeah, I'm just interested in that one. I mean, that one will probably covered more on TMZ. Let's see. And then, Barrymore.
Well, you're just going to have to take good notes for the rest of us.
I know. And I'll just get Tanner every video. I'm just kidding. Barry Morphew. This one's going to be wild. That's in Colorado. They found her bones, and from the bone marrow, they found the
DNA. Yeah.
It's
amazing,
wild.
isn't it?
Yeah.
Absolutely amazing.
Yeah.
This is the one where they had the fight and the neighbor hears somebody screaming in the woods. Is this Morphew?
Yes.
Yeah, because there's 2 Suzannes out there who've been victims. And
Colorado won't live stream. Well, this
for heaven's sakes.
I'm going to have to make a new list. But, well, I'm not going back to I just did not love Colorado when I was there. And then Shayna Gardner.
This is the one where the hitman recanted and then unrecanted, I think.
Yes.
Yeah. That's going to make it harder, particularly with the defense lawyer that they've hired, who's going to probably make a little bit of a circus over this.
Okay. Yeah. This one will be a lot of theatrics, and a lot of people speculate that Wendy will be watching to see how Jose does, because she might be looking for one. So anyhow, but that is the end.
That's your list?
Yeah.
There's a case I think that will be streamed in New Jersey. I'm trying to think of the name of the defendant, but it's a brother. There were 2 brothers, and they had a couple of businesses together. One of them was very, very successful. The other one, less so. And the very successful one had started to say he was going to cut the other brother out because he wasn't working and he was spending money. And the older successful brother and his wife and their 2 children were murdered. And the younger brother is being prosecuted for it.
Do you know what the name is? It's in New Jersey?
Yeah, it's I have it somewhere. I'm not good with names.
That's okay.
I've never been good with names, and I'm not any better now than before. I can text it to you. I've got it here somewhere. It's an Italian name. It might start with a C.
Okay. I'm sure I could Google
Yeah.
brothers trial, New Jersey.
Fire, also put arson in because
Arson.
he then tried to burn this house down to allegedly cover up the crime. I think it might be Monmouth County, although I don't want to swear to that.
There's a lot coming up in 2026. I get so burned up about Wendy. I'm like, I gotta look at some other stuff. So,
yeah. Well, there's certainly enough to fill in the time.
Yeah.
There's a lesson to be learned in all this, not with these two brothers in New Jersey, because, there's nothing the older brother could have done to not have the younger brother. But boy, you need to be careful about the people that you have relationships with or marry.
Isn't that the truth?
And if you get a spidey sense, and I can't believe that some of them didn't have some sense, you should walk away. Your spidey sense is likely to be right.
That is true. It never steers you wrong.
Yeah.
Yeah. Well, this was amazing. Thank you so much.
This is a lot of fun. I love your channel. I think what you do with graphics is just so creative.
Thank you.
And it helps so much when you're doing a case, when you're doing a presentation. So I just admire it. Well, and congratulations on getting to 10,000 subscribers.
Yeah, well, thanks. And thanks for being on my guest wish list. I mean, that took off more than I ever thought would. It was
it was so cute, though. What you want for Christmas? How could anyone have not responded?
There were two that didn't respond.
Oh, I can't believe it. Well, this was a lot of fun, and at some point, I just have started doing interviews on my channel. You'll have to reciprocate.
Yeah, would love to. And just a quick plug: tomorrow night will premiere. I had an interview with a forensic psychiatrist and child psychiatrist, and his main focus is parental and familial alienation.
Oh boy. So you're going to tie this to the Reiners, are you?
It's really just talks about the topic of it, but I think you'll be able to see a lot about different cases in it. So
I want to do something with someone who's an expert in that area to just talk about something I don't understand.
Yeah, he was fascinating. We sat down for a few hours, and then I did a recorded interview. I know him professionally here in Nashville.
Oh, good.
He said my real name like 3 times in the interview, like my full name. I mean, my real name is Leslie. I'm like, I gotta edit that out.
Yeah, see, you can edit out. I would have to start all over again.
Yeah, it is a lot of work, but it's fun. So
yeah. Well, so where do you live? Do you mind saying what state it is?
Yeah, I'm in Nashville, Tennessee.
Oh, that's a great city.
Yeah.
You have a lot of great music there. I'm a big country western fan.
Oh, we have a lot. Yeah. If you're ever in town, I'll take you to the good places, not on Broadway, the really good ones.
Okay. It's a deal.
Okay, sounds good. Thank you, everybody. Thanks, Jo.
Thanks so much.
All right. Bye.
Bye.
Leslie B. from True Crime in a Minute.
Leslie from True Crime in a Minute.
Leslie B. from True Crime in a Minute.
A shout out to Leslie from True Crime in a Minute.
Love you, and please join us at True Crime in a Minute.
So Leslie B., love her, met her at CrimeCon, and she has like the most magnificent makeup ever.